GPO Advice from Steve video. I'm Steve Durbin, Director of Cathedral Solutions Limited. We provide data protection services, including outsourced DPO, to a wide range of clients. If you're not already a customer, drop us an email at sales@xcathedral.solutions. That's sales@xcathedral.solutions to discuss becoming a customer. So I'm going to talk about a specific topic which comes up a lot for UK general practitioners. Most of what we're going to be covering isn't really applicable elsewhere, but it can be applicable to some other areas. And we're also talking about England and Wales law only. So if you're a family who've recently lost a loved one, my condolences on your loss. And I hope that if you do view this video, it'll help you understand better the things that the GP has to do as part of the process and why sometimes they have to tell you they can't do things. So firstly, data protection law only applies to natural living persons. That means that data protection law and all the data subject access rights end at death. So if somebody makes a request on behalf of a deceased person for a data subject access request under Article 15, we've got to refuse it because the right simply doesn't exist. So sharing data under that would not be legal. If the request was made before the person died by another person with their consent, I'd recommend that we do complete it because the law did apply to the time of the request. But if you're one of my customers, please feel free to consult me. It's not always that clear cut. One little aside, not a data protection issue, before we dive in. From the 1st of April 2023, there's a statutory requirement for all deaths, even expected ones, to be viewed by a medical examiner. Medical examiners will work with you to quickly release bodies for their religious reasons for urgent burial, but you have to involve them in every case. There's advice guidance on that for GPs on the NHS's websites. So, what data rights do the deceased have? Well, they maintain their right to privacy under common law. For those not familiar, common law isn't written law in the sense of being acts and the like, but it's formed from judges' decisions, statements on cases over hundreds of years of jurisprudence across England and Wales. That means it can be really difficult sometimes to find the right answer. And in fact, I'm updating this piece today because of a piece of a case law that was actually missed in the original one. So that does mean that it's really difficult sometimes to find the right answers. And the key piece here is that deceased are still entitled to some protection of their privacy. That means we generally have to respect the wishes they informed us of in life and have respect for other matters. So if the deceased stated they did not want their details, their medical history released to specific persons, even family, after death, we have to respect that. They can only be overruled by a court of law. In terms of sharing data, the deceased wishes, if known, must be taken into account. Now, we all know that medical records can contain some very private things. So when releasing information about the deceased, we need to consider their dignity and privacy as well as the needs of the family and the people asking for records too. So a common question is, who can we release information to? And a common wrong answer is next of kin. It's just not that simple, mainly because next of kin isn't clearly defined in law and it's completely absent in data protection law and the law around deceased person's medical records. The key law in England and Wales for this is the Access to Medical Records Act 1990, and that allows us to release information to two classes of people. So the first one is the deceased's personal representative, and the second is any person with a claim on the estate. So obviously that's got everyone scratching their head now going, what does that mean then? Okay, let's explain. So the personal representative depends on whether the deceased left a will or not. If they left a will, it will be the person named on the grant on the grant of probate, or if probate's not granted, the executor named in the will. Pretty easy to evidence because there's documents, the grant and the certified will to show this. If they didn't leave a will, there may be a grant of administration. Again, this is a court document, so easy to prove. If there's no grant, it will just be the person entitled to deal with the estate. This will generally be a family member, but it's a fairly horribly complicated order of precedence, so that can be difficult. For access to the deceased medical records, though, since the second category is any person with a claim on the estate, we can be pretty sure that a family member asking us who had a claim against them, or against the estate, against the will, would be entitled to access. So now we know we can ask. Well, what can we give them? Well, for the personal representative, we can give them pretty much what they need for the process, like maybe all or a very broad part of the record, always respecting the deceased wishes, of course. Since the leading case a few years ago, the view has been that the personal representative can request and should generally be given, if requested, the whole record. Now, to be clear, the law still allows us to remove some matters. For example, third-party information, where released that would breach data protection. Additionally, we can still remove matters that we believe have been told in life by the deceased they did not want shared. However, it's never simple, so please consult me. If you don't consult me, then you're not really using the contract you've paid for. For persons with a claim on the estate, it is limited only to evidence relevant to their claim. So we need to be a bit more cautious here. Generally, if we get multiple requests from a person with a claim, we should endeavour to provide everyone with the same information. We've got 21 days from the date of the request to fulfill the request, 40 days if any entries made in the last 21 days. So if the record's only just been updated. So that's all the legalese and the legal complications. But please bear in mind, we're talking a grieving family here. So you can go outside this if we can make judgment calls about the deceased confidentiality. So, for example, if a father had died of cancer and one of their offspring after it was hereditary, that's unlikely relevant to the estate, but there's generally not a reason for us to refuse. And certainly the late father would almost certainly have wanted their child to know this. So don't forget, if you're unsure and you're a customer, feel free to call or email us. All our contracts have no usage charges. There's no additional cost if you get an advice. We'll normally respond same day to emails. Also, feel free for topics to be added to these videos. I try to update as many as I can, but I'm always looking for feedback. And if you're not a customer, as I said earlier, feel free to drop us a line at sales@excathedral.solutions to see if you can become one. Have a great day, and I'll see you in the next video. Bye-bye.